I'm Kenneth Petroulis, the current chair of the Beverly Hills Bar Foundation's annual Rule of Law writing competition and a principal at Petroulis Fiduciary Services. For 17 years now, my wife Dale and I, believing that respect for the rule of law is necessary now more than ever, have sponsored this competition. Today, I'm delighted to introduce our speaker, Eleanor Haddad. Eleanor is a Juris Doctor candidate in the class of 2026 at USC School of Law. She serves as executive postscript editor for volume 99 of the Southern California Law Review. Her note about Kidfluencers, labor, and privacy rights was published in volume 99, issue 2 of the Law Review and won the 2025 SCLR Scribes Award for Excellence. Congratulations, Eleanor. Before beginning law school, Ms. Haddad spent 7 years working in the nonprofit sector, helping to build startup programs focused on social justice, health, education, and gender equality. She earned her BA in Law, History, and Culture from USC in 2016. Eleanor's presentation will be moderated by Kenneth Freundlich, Freundlich Law, APC, a leading entertainment attorney. And now, Ken, let's get started.
Hi. The only thing I want to correct about that is that Eleanor is no longer a candidate. I think she got her JD last weekend, right? Is that right?
That's correct.
Okay.
Yeah. So we've got a lawyer presenting a fascinating paper, and I'm not going to spend a whole lot of time on it, other than to say that it has a fancy Latin name, quis custodiet ipsos custodes, which I'm not sure exactly what it means, but maybe Eleanor will tell us. But the bottom line is Eleanor has studied kidfluencers and the problem of stage mothering on the internet and the use of potentially labor on the one hand and privacy laws on the other hand to solve the problems that she's identified. So without further ado, take it away.
Thank you. Thank you both. Well, as Kenneth said, my name is Eleanor. I am a recent graduate of the JD class of 2026 at USC Gold School of Law, and I'm very excited to be here talking to everyone today. The Latin phrase in the title of my note effectively translates as "who will guard the guards themselves," and I think it's a very fitting theme for what we'll be talking about today. And as a quick definitional note before we get into it, when I talk about kidfluencers as part of this presentation, I'm referring to children with monetized social media accounts on platforms like YouTube and TikTok. So to ground our discussion for today, we're going to be looking at a specific case study, which is the lawsuit involving former kidfluencer Piper Raquel and her mother, Tiffany Smith. So Piper Raquel, she's now 18, but she is a former very prolific kidfluencer. Her mother, Tiffany Smith, was also her manager. Piper was mainly active in the late 2010s to early 2020s when she was about 10 to 15 years old. She had, and still technically has, tens of millions of followers across multiple social media platforms, and her platforms have an annual revenue just for advertising alone of between about 4.2 million and $7.5 million a year. Most of her content featured herself and her group of friends who were about the same age, all minors, self-nicknamed the Squad, and their content mostly involved them doing skits and pranks and things like that. In 2022, former members of the Squad, still minors at this point in time, sued Tiffany Smith in Los Angeles Superior Court, alleging, among other things, that they had devoted oppressively long hours, in some cases more than 12 hours a day for 7 days a week, to producing hundreds of highly lucrative videos, but were never compensated and were denied rest breaks and meal breaks during filming, did not receive regular schooling, And they also described being pushed to film invasive sexualized content, much of which is still online today. As an example, these are thumbnails from Piper Raquel's YouTube channel. They are pretty emblematic of the kind of content that the squad was putting out. These are specific to some squad videos. And so in 2024, early 2024, the judge that was overseeing the case denied Smith's last motion for summary judgment and ruled that the case would go to trial in December 2024. Ahead of that, the parties settled in October 2024 for $1.85 million. And so how did we get here is the general question that sparked my note. How is it possible that a situation like that at issue in this case carried on unchecked for years? The brief starting answer to that is that we don't regulate kidfluencers for the most part. And then what can this lawsuit teach us about how to close the gaps in kidfluencer protections moving forward? My brief answer there is that this lawsuit illustrates how kidfluencing poses risks of both labor and privacy exploitation. And so effective kidfluencer regulations would cover both of these areas. So to start us off, a bit of background about the influencer industry and how the kidfluencer phenomenon came to be. As you can see from just these brief statistics, this is a hugely lucrative industry and it is growing. And for kidfluencers who have at least 1 million followers, they can make more than $10,000 for just a single social media post. And so this system creates huge incentives for parents to monetize their children. And while kidfluencers are a recent phenomenon, the conflict of interest that kidfluencing presents between parents and children has much deeper roots. In fact, if we look back at the experiences of child performers during the vaudeville and early motion picture eras, when labor protections for child actors did not yet exist, they also commonly experienced exploitation. And it was this very exploitation that prompted the entertainment industry to begin enacting the more robust protections that traditional child performers have now. In terms of how kidfluencers specifically came to be, I see the arrival of reality television programs featuring children as main cast members beginning about 15 years ago as the catalyst. These shows generally coincided with the launch of Instagram and similar platforms, and so children who built fan bases on reality television shows as themselves rather than as a fictional character simultaneously grew large social media followings. And even though there are key distinctions between kidfluencers and traditional child actors, examining labor protections for child actors is relevant to the kidfluencer discussion, both because it illustrates just how unprotected kidfluencers are by comparison, but also because it serves as a model for what kidfluencer labor protections should entail. Because after all, protections for child actors were created with the same conflict of interest in mind as that present in the kidfluencer context. And so starting with the federal scope, the Fair Labor Standards Act has always had a carve-out for child performers as well as for children employed by their parents. So there's no federal protection, certainly for kidfluencers, but also for traditional child actors. However, protection for child actors is pretty robust through state laws and in California and New York in particular, and through SAG-AFTRA, which is the primary entertainers union. But those protections do not apply to kidfluencers. So instead, kidfluencers have come to occupy a kind of legal gray area somewhere between professional child performers and kids next door getting together to make a funny video. And so if we look at the circumstances within which Piper Raquel's content with the squad was produced against the requirements for traditional child actors in California, where this content was filmed, we can see that none of these protections were present in the squad situation. Specifically, California's requirements for child performers that Tiffany Smith and the Piper Raquel filming situation did not meet include just compensation in general for the work performed, but also protected block trust accounts that are accessible only to the child upon reaching age 18. In California, this is called a Coogan account. Permits to employ minors, regular onset education, limits on working hours, and constant onset supervision by a state licensed teacher or a welfare worker. California requires these for child actors, but they weren't present in the Piper Raquel situation. Notably, some states, and specifically the 7 states in blue here, have recently taken steps to protect Kidfluencers' compensation by mandating Coogan-esque trust accounts for them, and this is certainly an important step forward. But the Raquel lawsuit shows us that compensation safeguards alone are not enough. In addition to the labor abuses that Kidfluencers, like members of the squad, suffered, which include but also go far beyond lack of compensation, Kidfluencers are also at a unique risk for exploitation of their privacy. Unlike child actors, Kidfluencers are not playing fictional characters, they're playing themselves, and they're not being filmed on a set, they're being filmed at home. And so in addition to labor protections, they need protection from privacy exploitation as well. So now when we look at the existing framework governing children's privacy, the law in this area focuses on children as social media users rather than as content fixtures, and parental consent waivers also feature heavily here. So in particular, the Children's Online Privacy Protection Act, which is the primary set of federal regulations governing data collection of children online, it focuses on children as users, and also its requirements are waivable with parental consent. Platform user age restrictions, virtually all platforms, all major platforms have some kind of restriction on the age of someone that can be a user on the site. Depends which platform in terms of what age it is. Sometimes it's 13, sometimes it's 16. Regardless, it seems that these restrictions are surmountable if an account claims to be managed by an adult, even if the account is primarily or exclusively featuring content involving a minor. And then the right of publicity, it's of course distinct from the right of privacy, but it's relevant here in the Kidfluencer context as it enshrines the right to control the commercial value of one's identity. And the right of publicity is also waivable with parental consent for children. And so because of these gaps, existing privacy laws need to be adapted to respond to Kidfluencing's unique privacy risk. And ideally, these adaptations would have an ex-ante component that works to disincentivize parents' casual sharing of invasive content about their children in the first place. But at minimum, they should give Kidfluencers or former Kidfluencers a mechanism for objecting to content that features them and get that content taken down. To that end, 4 states, those in dark blue here, have enacted Kidfluencer laws with some kind of takedown provision. However, 2 of those states simply require that Kidfluencers have a means to request that content be removed and don't actually require an adult creator or a social media platform to comply with that request. Only Arkansas and Montana have actually gone so far as to require removal upon request. In Arkansas's case, the state takes creators out of the equation entirely and lays all responsibility on platforms to remove content that Kidfluencers object to. This measure represents the kind of approach that I argue needs to be adopted much more widely. So, in weighing all of this information, I see a multi-pronged approach or solution take shape, where a comprehensive set of Kidfluencer protections would cover not only labor, but privacy protections as well. And it can pull from existing analogous law in both areas to do that. Then these regulations need to be enacted federally in order to be truly effective, because the internet transcends the geographic barriers that made a state-specific system more practical for traditional child actors. But lastly, social media platforms need to play a role here because they're the only entity other than a creator that would have the ability to comply with a Kidfluencer or former Kidfluencer's content removal request in the event that their parent cannot or will not do so. Now, a solution that involves platforms in protecting Kidfluencers in this way would implicate Section 230 of the Communications Decency Act, which exempts platforms from liability for third-party content focused or posted on their site. However, Section 230 does have a carve-out for intellectual property law, and the Digital Millennium Copyright Act accordingly requires platforms to take steps to remove infringing content in order to qualify for its safe harbor provisions. And so the DMCA is thus a relevant model here because just as Congress has imposed on internet providers a duty to take down infringing material when given notice to do so and otherwise to not contribute to copyright infringement, Congress could also impose similar takedown duties here and could also specifically require that providers not contribute to the exploitation of Kidfluencers by requiring them to refuse to allow or to take down posts when parents have not documented compliance with the to be enacted federal labor-related restrictions, and to take down posts upon the Kidfluencer or former Kidfluencer's request. And thus, Kidfluencer regulations that involve platforms as enforcers arguably need not violate Section 230 at all. And so we arrive at this three-pronged solution that I argue would be the most effective means of closing the gaps to protect Kidfluencers. And with that, we'll transition to Q&A.
Well done. I'm going to ask you a few questions, and I wanted to just ask the moderator, are the people in here going to be able to be audio heard, or should they be putting all their questions into the chat?
So questions will be going into the Q&A box. In the Q&A box, we'll be able to see them in the open section.
I do not see a Q&A box at all here, but
it'll be within the more field. You might see more with the ellipses.
Okay.
Q&A.
Q&A. Okay, I'm good. So I really encourage you, because the rest of this is only as good as the questions, and I don't want to be the only one asking the questions, but I'm going to start. So there was, as we discussed the other day, a recent ruling by the Supreme Court in a case called Cox Communications Inc. versus Sony, which I think has the effect of narrowing the possibilities of getting the platforms to do anything here. Can you comment on that, or have you considered that?
Yeah, I have. I think that Cox in general, because what we would be looking for a Kidfluencer set of regulations would be a new law, entirely new legislation. I think Cox would be an important and necessary consideration for Congress in drafting a new law, but really it represents a narrow reading of contributory liability specific to the Digital Millennium Copyright Act. And so I don't think it forecloses what Congress could do to enact Kidfluencer regulations, but it does represent something important to consider, and specifically how Congress would define contributory liability in a DMCA-inspired Kidfluencer federal regulation.
Well, I know that, for instance, YouTube has an algorithm that actually promotes Kidfluencers content, and its monetization program affirmatively selects those accounts for revenue sharing. So they don't really care much. I wonder if that, in your view, that combination of YouTube activity potentially satisfies even Sotomayor's, narrow view that there has to be activating and abetting in order for the DMCA approach to apply.
I think so. I think that Sotomayor's concurrence is quite relevant here for the reason that you point out, and in looking at how the most relevant platforms here are set up and are engaging with Kidfluencer accounts.
And then Cox also basically says that Congress should do the work here. So I think that kind of feeds into your COPA amendment strategy. So what is your, if you were the one up there lobbying, what would be your realistic legislative pathway to give existing momentum around the COSA and COPA and state kidfluencer laws?
So I think COPE is really, really interesting, especially because I mention it, well, it's on the slides, but I didn't talk specifically about it before. We have this COPA 2.0 amendment that's been reintroduced at least a couple of times over the past few years, and it's not become law at this time. But the big thing that it adds is it defines an additional class of protected minors, in this case, minors over the age of 13, because COPPA itself does not apply to children over 13, and also protects them as users and has regulations for data collection from them. But for those teens, as defined by this COPPA 2.0, the teen is the one who consents or revokes consent to their data collection. And I think that's very interesting because it recognizes that, at least for children as social media users, there comes a point, perhaps before age 18, when they have the wherewithal to consent or not, or to revoke consent for content that, or data that is that they turn over. What I think we would want to do first is have an amendment that doesn't just treat children as users, but as the content fixtures that they are if they're in monetized platforms, and that also has the effect of making parental consent to data collection or content, etc., provisional only, so that right now, even under COPPA 2.0, if a parent consents to data collection of their child before that child is over 13, and then the child later wants to revoke that, they can't with how the law is currently written. And so there should be a mechanism for children or former kidfluencers after the fact to revoke that consent, even if they were at an age when it was collected. They were at an age where their parents were the one giving that consent.
But is there really? I mean, I know in Europe there are statutes that allow you I forget what they call it right now. It's like the ability to be forgotten or something, where you can
the right to be forgotten.
Yeah, you can actually go to these services in Europe, in certain countries, and eliminate all your history from the internet. Is that really something that can be even done here technologically? I mean, once you're up there and you're in all these places, scrubbing yourself off is really difficult.
It's a very good point. And it's something that I remember when I was researching for my note, that lawmakers in some states had thought about something in the vein of what the EU has, and then had abandoned, mostly from practicality and logistical concerns, I think was what I read. And I think
the biggest problem, I'm sorry, go ahead. You think what?
No worries. I was going to say, I think that this is a scenario where we don't want to let the perfect be the enemy of the good, because there's a spectrum, I think. There's another former family vlogging family, and I won't get into the weeds of who they are, but I talk about them in my note, and a lot of the content that they were posting, it's relevant because it kind of stops short of that kind of sexualized content that the squad was putting out there, but it's still the kind of content that you can absolutely see a child not wanting to have out there forever. So this family vlogging account has been deactivated since 2023. And so you can still get some of that content on, for example, the Wayback Machine, like the Internet Archive. And I confirmed that for myself when I looked it up there to access it. It is much harder to access, though, and there's a lot less of it when you compare that to Piper Raquel's account, which was demonetized after the lawsuit in 2022. But it's still up.
Was it deactivated by the family, or was it deactivated by the service?
It was deactivated by the family.
Ah, so the parents had a second thought about it.
There was a lot that seemed to have gone down in that family, and I think the account was it might have been that the original account was the same account, but they changed the name of it and they deleted all of the content off of it.
Because I know that from my experience being in entertainment, I've had a lot of experience with the studio teachers and all the so-called protections. And the reality is, it's very difficult to regulate parents in terms of how they deal with their children. And it was one thing when the parents had to go to a set and it was a fairly public place, and even the way the teacher taught was a fairly public room with a bunch of, you could open the door. Whereas here, you're a lot of times inside the parent's house, which is the conundrum we're in. And then it gets even worse, I think. Maybe you want to comment on this, where the parents start to monetize it by creating like a house and having other kids' children come into their house. It's a mess, and it's very hard to regulate.
It's totally a mess. I think this is also part of the reason why, I think we have to have some kind of a means for requesting removal, like takedown requirements. But I think that ideally we would also have like an ex ante system that at least makes it more difficult to get monetization status and to put all of this content up, because I think part of the problem right now is that it's just really easy to
film sorry,
the flat ban that Minnesota put.
Like, why don't you just say, hey, you can't get on a monetized internet till you're 14, and maybe that's what we need. I mean, we don't let people drive cars until they're a certain age. There should be some rules here, and I think a lot of parents not only looking at the kidfluencers from outside, but just their own kids. They don't even want them to interact with this content a lot of times, and I hear that a lot of times.
Completely. I mean, I think a flat ban like that Minnesota has taken out, I think it's well worth lawmakers' consideration. Absolutely. I think it's one of those tricky things. This is one of the many parallels that I sort of saw between right now and 100 years ago and the early motion picture industry. And it was kind of this new thing that, and people weren't sure what it was going to become and what it was going to look like. And children needed protections. They took a while to be created. And I think it's well worth consideration to just have a ban. I also think that just like we've seen children need protections in the film industry because they are this enduring presence. They did stay. There's clearly a demand for content that they're in. We might see that being the overall feeling that society has about children in social media content. And then it becomes, okay, they're going to stay in this content. How do we make it as safe as possible and as regulated as possible in this setting?
All right, we've got one question actually from Ken, Kenneth P, who introduced us, and I'll throw it out there. He said, did you consider the protections available to child actors that could be just transmuted onto kidfluencers, for instance, the Coogan accounts and things like that? Do you think it's a simple thing to do that, and how would it be done?
I think simple is maybe a challenging word. I think it's simpler than cutting legislation out of whole cloth, especially when we have seen this legislation be effective in an existing context of the traditional entertainment industry. I think that absolutely not just mandated Coogan accounts, which I do think makes sense. I mean, children need to be compensated if they're being part of making this kind of profit. They deserve to have their earnings protected. We know that Coogan accounts work, and they've done a lot to get in the way of the damage that was wrought before they were required. So I absolutely think that they should be extended to cover kidfluencers. But I also think that regulations like what we see in California, where you've got mandated amount of educational hours that a child needs to have depending on their age and the day of the week and how many hours filming and things like that, those should be required. A huge one is this requirement of on-set supervision and advocacy, because in California and New York, that doesn't even mean that the child's parent, the child's parent, I believe, is also required to be there. But when they say on-set supervision and advocacy, just having the child's parent there actually won't cut it. And that's good because of the obvious situation that we have with kidfluencers. Those states are talking about a state licensed teacher or a welfare worker. So you have this other representative who's not motivated for the same reasons as maybe the adult creator is motivated to be there. They're just there for the children's welfare. That would have gone a really long way with the squad situation.
Boy,
so
that yeah. I could see what the many problems with that one. Letting someone come into the house, and what are they going to see, and what do they have to report, and blah. Anyway, I think we're at 4:30. I think that's the time, but I do want to take moderator's prerogative to say one thing. First of all, I thought your article was brilliantly written. And the sad part for me would be if you were to go off to your job now and just let this drop as a hobby piece. So I want to encourage you to even while you're working hard where you're going to be in the fall to try and, you know, implement some of these things, like try and get in contact with people that are actually doing something about this and make yourself known, because you've done some really good thinking here.
Many thanks to you, Ken. I really appreciate it. And absolutely, I don't want to let this one drop. It's a passion at this point.
Yep, and you're in the right place. I mean, this is, you know, Los Angeles is probably the hub of a lot of this stuff. Yeah, so as Mr. Petroulis would like me to remind everybody, please, if you're not already a member of the BHBA, join and help us to change the law, because we certainly need it to be changed, not only here, but in many other things that are happening these days. So thank you very much for joining. Eleanor, thank you so much. Good luck with the bar and good luck with your career. And I'm sure we'll be hearing great things about you as years pass.
Many thanks. Thank you so much.